Hi, this is Dan Smith of DPS Legal Counsel, and welcome to today's episode of Business is More Exciting Than Any Game. Today I'm going to be talking about trademark assignments, and in particular the doctrine of assignments in gross, or what is sometimes called naked trademark assignments. What this relates to is the requirement that if you have a trademark assignment, you need to also have, in conjunction with that trademark assignment, an assignment of the underlying goodwill of the business that is making the assignment. The rationale for this is that a trademark is intended to reflect or show or demonstrate the source and identity of goods and services. So if you have a trademark assignment that does not include the underlying goodwill of the business that's making the assignment, you might end up with a product, a good or service being introduced into commerce that is different in quality or type than the good or service that has been in commerce under the trademark prior to the assignment. For example, if you have a company that has a registered trademark for a restaurant that sells strictly fried chicken, and it assigns its trademark to another company, and that new company uses that trademark to have a cafe that sells only croissants and coffee. Well, you now have a very kind of confusing situation where consumers don't know what that trademark really relates to anymore. Does it relate to fried chicken? Does it relate to coffee and croissants? And so you don't, by not having that similarity of goods and services after the supposed trademark assignment, you have basically caused such damage to the trademark that the trademark assignment itself is treated as invalid, because it is called, in this case, it's called an assignment in gross. You've assigned this trademark, but you haven't assigned the underlying business goodwill, and that's shown by the fact that there's not a similarity in services or goods after the assignment. There was a recent case a couple of weeks ago came out of the a federal court in Washington State, and it involved a purported trademark assignment for a restaurant that sold, well, it's a little confusing, so let me just kind of tell you what the facts are. There is a restaurant company in Washington State that has about 3 restaurants, I believe, in the Seattle area that sells fried chicken, macaroni and cheese, biscuits, tacos. It's a fast food restaurant, and it operates under the trademark Baka Bak. The words Baka Bak, which is intended to approximate the sound that a chicken makes. It also has a little stylized logo with the name Baka Bak that looks like a chicken head in different colors. And so that company operates in the Seattle area under its registered trademark. It became aware of another restaurant company in Nevada that was using the trademark Bak Bak. Similar sound, spelled the same. It doesn't have the word A in it, Baka Bak. It has just Bak Bak. And so the company in Washington State, Baka Bak, sent a cease and desist letter to the company in Nevada, and the company in Nevada responded, and then ultimately the company in Nevada filed a lawsuit against the company in Seattle. Prior to having filed that suit, the company in Nevada acquired a trademark assignment from a restaurant company in New York State that operates a business called Bak Bak Chicken Delicious, and it also has a registered trademark. Now let's talk about what these different restaurants do. The one in Seattle in the Seattle area, Baka Bak. I mentioned what they do. They sell fried chicken, macaroni and cheese, biscuits, tacos. It's a fast food restaurant, but these are standalone restaurants. The company, or the restaurant company in Nevada, Bak Bak, is basically a restaurant or restaurants that sell a variety of Mediterranean food. And then the company in New York, Bak Bak Chicken Delicious, is a company that has sells Korean-style chicken in malls, in the food courts of malls. And so once the company in Nevada acquired this trademark license from the company in New York for Bak Bak Chicken Delicious, it actually sued the company Baka Bak that had originally sent it a cease and desist letter. Well, of course, you have the lawsuit, you have counterclaims. It's all very confusing on one level, but it's not confusing on another. It all gets down to who has certain trademark rights, who doesn't have certain trademark rights to the name or the sound or the trademark Bak Bak or Baka Bak, and ultimately in this case, the main issue was whether the trademark assignment that the Nevada company got from the New York company was a valid trademark assignment. Here was the issue. That's the issue. And here's how the court looked at that particular issue in specifics. It essentially looked at what was the company in New York with its registered trademark, Bak Bak Chicken Delicious. What were the goods and services that it was selling under that trademark? And the answer is it was selling Korean-style fried chicken in food court locations. It was essentially a restaurant chain with locations in mall food courts selling Korean-style fried chicken. So when the company in Nevada got that Bak Bak Chicken Delicious trademark assignment, what was it doing with that trademark? Well, it was selling Mediterranean food. Okay, the court basically determined that there was not a substantial similarity in the goods sold by the recipient of the trademark assignment from the goods or services sold by the seller of the trademark assignment. And so the trademark assignment was invalid as an assignment in gross or a naked assignment or a naked trademark assignment. That meant that it basically lost, based on this court's determination, in its claims against the company in Seattle. And in fact, the company in Seattle was able, in this particular court case, to get a summary judgment entered in its favor, finding that the company in Nevada actually infringed its trademarks and had engaged in unfair competition. And the company in Washington not only won that particular case against the company in Nevada, but the company in Seattle also got attorney's fees awarded to it. Now that case was in a federal district court case. It may still go up on appeal, and it was a case that was determined at the summary judgment level. But it's interesting in its discussion of the doctrine of assignments in gross in connection with trademark assignments. You can see that just by getting a trademark assignment, unless you get the underlying goodwill and unless you continue providing the same quality and same kind of goods and services that have been provided under the trademark prior to the assignment, it can be determined that the trademark assignment is just invalid and of no benefit, of no use. And so that's kind of what the court decided in this particular case at the district court level. So anyway, that's it. If you want to read that case, it's a very interesting case. Let me look at the heading of it. It's called BBC Group NV LLC. That was the company in Nevada versus Island Life Restaurant Group LLC. That's the company with the Baka trademark in Seattle. And it is it was decided in the Western District Federal District Court of Washington September the 20th of 2019. So if you want to check that case out, I'm sure you can find it online someplace and read it. It's very interesting in how it treats the whole issue of assignments and gross. Okay, I hope that helps. I hope you've learned something today about trademark assignments and assignments and gross, and what the whole issue of having underlying goodwill accompany the trademark assignment's all about. If you have any questions, please don't hesitate to let me know, and we'll see you next time on Business is More Exciting Than Any Game.